Hello friends, in this video I will discuss the Medical Termination of Pregnancy Act 1971. This act implemented in 1971. The matter is not like this, that there was no law regarding the termination of pregnancy. Rather, before 1971, the termination of pregnancy law or abortion law was followed as per the provision of the Indian Penal Code. The provision defined purposely causing miscarriage as the penalty for abortion. Practitioners was either 3 years in prison or fine or both. On the other hand, for the woman availing of any abortion, the penalty was either 7 years in prison or a fine or both. However, the only exception was when abortion was induced in order to save the life of the respective woman, otherwise it was punishable offense. As time changed, the Government of India has implemented an exclusive law to deal with abortion. Therefore, in this video, I will discuss the Medical Termination of Pregnancy Act 1971, the law that deals with abortion. However, before I start discussing the act, let's understand first what is all about the Medical Termination of Pregnancy Act 1971. It is an act to provide for the termination of certain pregnancies by registered medical practitioners and for matters connected therewith or incidental thereto. Now, the next question is, when pregnancies may be terminated? As defined in the provisions of subsection 4 of this Act, a pregnancy may be terminated by a registered medical practitioner where the length of the pregnancy does not exceed 12 weeks. It means if pregnancies are not exceeding 12 weeks, may be terminated based on a single opinion formed in good faith, or where the length of the pregnancy exceeds 12 weeks but doesn't exceed 20 weeks if not less than 2 registered medical practitioners are. It means if pregnancy is exceeding 12 weeks but less than 20 weeks, termination needs opinion of 2 registered practitioners. Further, Clause 3 of Section 3 of this Act states that while determining whether the continuance of pregnancy would involve such risk of injury to the health as is mentioned in subsection 2, account may be taken of the pregnant woman's actual or reasonable foreseeable environment. It means such abortion must be done only after considering the present and future health of the woman. Further, Clause 4 of Section 3 of this Act states that no pregnancy of a woman who has not attained the age of 18 years or who having attained the age of 18 years is a lunatic shall be terminated except with the consent in writing of her guardian. It means in a condition when the pregnant woman has not attained the age of 18 years, she attained the age of 18 years, but she is lunatic. In such a condition, abortion can be done only after taking the written consent of respective woman's guardian. Further, no pregnancy shall be terminated except with the consent of the pregnant woman. So, without woman's consent, her pregnancy cannot be aborted. Now, the next question you might have, that is, what are the conditions in which pregnancies can be aborted even after 12 weeks of pregnancy? Following are the conditions in which pregnancies can be aborted even after 12 weeks of pregnancy. That is, the continuance of the pregnancy would involve a risk to the life of the pregnant woman or of grave injury, physical or mental health. Or there is a substantial risk that if the child were born, it would suffer from such physical or mental abnormalities as to be seriously handicapped. Or where the pregnancy occurs as a result of rape, or where any pregnancy occurs as a result of failure of any device or method used by any married woman or her husband for the purpose of limiting the number of children, the anguish caused by such unwanted pregnancy may be presumed to constitute a grave injury to the mental health of the pregnant woman. Or pregnancies in unmarried girls under the age of 18 with the consent of her guardian. Or pregnancies in lunatic women with the consent of her guardian. Now, the next question is where pregnancy may be terminated. As defined in Section 4 of this Act, pregnancy may be terminated in a hospital established or maintained by government, or a place for the time being approved for the purpose of this Act of government, where pregnancy may be terminated. As defined in Section 4 of this Act, pregnancy may be terminated in a hospital established or maintained by government, or a place for the time being approved for the purpose of this Act by government. Now, the next question is, in such a case, can a legal action be taken against the registered medical practitioner? As per the Section 8 of this Act, no suit for other legal proceedings shall lie against any registered medical practitioner for any damage caused or likely to be caused by anything which is in good faith done or intended to be done under this Act. So in a normal circumstance, if it is done in a good faith, then no legal action can be taken against the registered medical practitioner. But note, notwithstanding anything contained in the Indian Penal Code 45 of 1860, the termination of a pregnancy by a person who is not a registered medical practitioner shall be an offense punishable under that code, and that code shall to this extent stand modified. It means if any such pregnancy is terminated by not a registered medical practitioner, then it shall be a punishable offense. So, this is all about the Medical Termination of Pregnancy Act 1971.